Hey, I'm not a lawyer and I don't play one on TV, but I am with one who could talk to you about some rather important legal developments that could affect you in the cybersecurity career path. So stay tuned. Hello and welcome to another episode of CISO Tradecraft, the podcast that provides you with the information, knowledge, and wisdom to be a more effective cybersecurity leader. I'm your host, G. Mark Hardy, and today I have with me a dear friend of mine, Larry Dietz, whom we've been company friends for, well over a decade, and maybe going into a second one. But Larry, welcome to the show.
Well, thanks, Mark. It's always a pleasure to banter with you. We do have fun, and occasionally we even provide informative information.
Imagine that, something that could be useful. Well, today we're going to examine three recent major cybersecurity developments from three different branches of government. I thought this would be kind of an interesting civics lesson. So, for those who've been paying attention, Congress failed to renew a significant foreign intelligence surveillance authority. That's the first one. The second one is the Supreme Court. They ruled that obtaining a detailed location information through a geofence warrant constitutes a Fourth Amendment search, which creates certain rights for the person being searched. And the Department of War has suspended the next phase of Cybersecurity Maturity Model Certification, or CMMC implementation, just months before that third-party Level 2 certification requirement was scheduled to expand to include all these little companies. So they kind of seem unrelated, but they kind of raise a fundamental question. Who can obtain or compel access to information? What legal authority permits it? And then what obligation remains when the government changes the rules? So, Larry, you are a lawyer, but I first want to warn everybody else out there that this show does not constitute legal advice. It's simply educational. You may have to say that too. But Larry, you're the general counsel of TL Global. You do contract law, plus cybersecurity, data privacy, and how to handle sensitive information. Tell us a little bit about yourself and how you ended up where you're at now.
Well, we probably don't have enough time for me to get the whole background.
Well, thank you, and there's plenty about it. No,
let me just give a brief snapshot. At the current moment, I'm general counsel for TAL Global, TAL, not an acronym, got his name. Private detective, president of the World Association of Detectives with the unfortunate acronym of WAD. Obviously, there are no marketing people in that association. I've been a cybersecurity professional since inspecting crypto facilities in Vietnam in 1969. I've also done research on the market for cybersecurity back in the 80s for Frost & Sullivan. More recently, I worked for Symantec for 6 years, where I ran analyst relations for the Gartner type analysts and the like, competitive intelligence, government relations, and did some other important marketing stuff. In April of 2007, I joined TAL Global, originally as their cybersecurity guy, but we quickly figured out that they're a physical security company and there's no way to turn an elephant into a giraffe. So TAL Global, we partner with Fortalice, which is our cybersecurity partner. And in April of 10, I became general counsel. And as such, I do rep agreement, I do personnel stuff, I review office leases. And lately, I've had to do a lot with data privacy compliance. In addition to all that, because Her Majesty the Queen Mother, my wife and I like to travel, I teach online. I've been teaching online from American Military University since 2008 or 9. And right now I'm teaching cybersecurity, introduction to the intelligence community, senior seminar in intelligence, and SIGINT, all at the undergraduate level. In 23, I started teaching for the Institute of World Politics at the graduate level, iwp.edu, where I teach intelligence and policy. And once a year, my favorite course, I teach negotiation skills for law students at Monterey College of Law. Consequently, I'm involved as an academic with respect to the FISA. Prior to this, once upon a time when I first started practice of law, I'm 0-1 in criminal defense. So I think that's probably enough background, Mark. What do you think?
It is. And of course, so you're also a retired colonel. So
Yes.
you too have earned the Eagles as well, so thank you for your service. So let's get into the subject matter today. And first of all, as I say, kind of a basic civics lesson for those who don't remember the 10th grade. And we talk about the three different types of government action. Congress will create or allow statutory authorities to expire. So they could say, hey, here's a law, or they could say, hey, we're not going to extend the law. Courts will interpret the constitutional and statutory limits as if to say, yeah, that was a little bit too much and you can't do that. And of course, the executive agencies will implement those laws, and they do so through regulations, policy directives, contract clauses, and things like that. But these are not interchangeable actions. If you have a bill that doesn't pass, it doesn't necessarily terminate every existing authorization. For example, in this case, with respect to FISA and surveillance, a Supreme Court decision may recognize that there is a search that occurred, but it's not necessarily going to decide whether it was reasonable or unreasonable. It's going to kick it back down to a lower level. And some agency memorandum may suspend an implementation, but doesn't remove the regulations. It just simply goes ahead and places it on hold. So what we'd like to do is sort of separate the headlines from the legal consequences that take place. So let's start out with FISA Court and Section 702. So when we talk about 702, it's 702 of what?
Well, it's 702 of the basic law, and the spirit of the law, Mark, is that the U.S. Constitution does not want the government being intrusive to its citizens. And by extension, people who are in the United States are afforded certain protection. And so the real purpose of this section is to allow our beloved three-letter agencies to collect intelligence on non-U.S. persons who the agency reasonably believes are located outside the United States. That's kind of the name of it.
Right. So the Foreign Intelligence Surveillance Act had certain sections in there, and one of them talked about that, which really, as you had said, it prohibits intentionally targeting Americans. Nonetheless, it's possibly kind of swept up in that dragnet. They're primarily focused, and this is all that took place post 9/11. They're trying to identify through intercepted communication signals, intelligence, etc., ways that they could potentially see where the next attack might be being planned or coming from. Now, this particular Senate had a very short clean extension bill, Senate Bill 4344, which would have extended the FISA authority, Section 702, until April of 2029. And it didn't really change anything else. It was very, very short. And what happened? I mean, did it just fail?
As you know, Mark, unless you've been living under a rock, we live in an incredibly partisan world. And that bill died in a gridlock. The Congress was very divided whether to attach warrant requirement. A warrant is where the prosecutor goes to an impartial judge and says, Judge, I have probable cause, I have good reason, I have this, and I need to get this permission from the court to do something. And so one faction in Congress thinks, yeah, you got to do a warrant for everything. And the other says, I'll be a little dramatic, Mark. You're a prosecutor. You're a good guy. We're going to do whatever you say because you're a good guy. You have a badge. And so there was that kind of conflict. But officially, the law expired on June the 12th of this year. However, buried in there is the Foreign Intelligence Surveillance Court, acronym FISC, which is able to get certifications for like a year at a time. And so the executive branch secured a 1-year certification on St. Patrick's Day, fittingly enough, March 17th on 26th. So the law will continue until March of 27.
Which may mean there might be some time to relieve that gridlock. And so it's interesting because that annual certification, that extension, that was a deliberate part of the law. I remember right after 9/11 that there was a lot of effort to go ahead, and the legislation, you had things such as the Patriot Act, et cetera, came out pretty well baked in such a short period of time. And you have to think that somebody had been working on it for quite a while. and working out the details. And just like the J5 at the Pentagon, where we have plans for just about any contingency, pretty sure that
You
the
need
plan for
you need to tell people that J means a joint staff, Mark, and
yes,
5 means planning.
correct. For those who are not familiar with the general staff alphabet soup that we use, I'm pretty sure there's a plan written by John Candy for the invasion of Canada, which we dust off every now and then and keep up to date. Nonetheless, and levity aside, what we find out then is that the idea that the legislation came out when Congress passed it, they didn't make it permanent. They put a fuse on it so that every so often it would have to be renewed so that in a future generation, these not necessarily suspensions of civil liberty, although some will certainly view them that way, but perhaps intrusions into civil liberty is a more agreeable term. They would not persist forever. And that gave them the sufficient support to go ahead and pass the law. And quite honestly, that probably wasn't such a bad idea, meaning that if the conditions for why this law was passed no longer exist, why continue to go ahead and do these things? Now, there's some people that would suggest that we are still in quite a concerning situation with regard to foreign activities and possible bad actors doing things in the United States. But that's really kind of up for Congress to do stuff. Now, one of the things that drove a lot of the controversy was what was called sort of a backdoor cert. And so I think you alluded to that, but what does that mean if we go into a little bit more detail here?
Well, the front door, of course, is where NSA legitimately targets a foreign entity abroad. No harm, no foul.
Mm-hmm.
That data, all of the hoovering, for those of you who are not old enough, Hoover was an old vacuum cleaner brand. The hoovering of the data has scooped it up, and there's a significant database. So if I'm Special Agent Dietz, God forbid, I can do a search into the database as an FBI agent and look up who's in there without ever doing a warrant. And so some argue that that's a breach of the Fourth Amendment. And unfortunately, I think the record has shown that there's been some problems with that. My girlfriend, Gemini, tells me that there were some individuals involved in the January 6th Capitol breach. There were some participants in 2020 racial justice protests and searching for political donors to congressional officials, etc. Allegedly, the FBI has implemented stricter internal guidelines. Now, having said that, and being licensed to talk out of my mouth by the state of California and the District of Columbia, let me point out that if the FBI gets a piece of information, they can use it to get other pieces of information legally. And so while that there may be an issue here, but you as a party would have to have the resources to track it backwards and say, Your Honor, this piece of information that led to ABC was obtained illegally without a warrant against the Constitution and is fruit of the poisonous tree, according to the world-famous Woson Supreme Court case. However, the odds of that happening would be pretty small. Also, the FBI can say, I didn't do it. Gemini did it. ChatGPT did it. And so law enforcement can enlist the impartial AI and appear to be blameless because it was AI did it, like the dog ate my lunch. So I think there's still the possibility of these backdoor searches. Yeah.
Yeah, and let's cover, for the sake of our civics lesson, let me read the Fourth Amendment to the Constitution of the United States.
Okay.
Okay, it's back when
I'll
amendments
drink
were
to that.
one sentence long. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. All right, so Not bad for, 1791 plus or minus, if I remember my dates correctly.
The room where it happened.
And so as a result, we find out, and people say, why are these amendments? Well, they kind of missed the first cut when they wrote the Constitution, and they realized, yeah, we probably should have included these things, but we already sent it off to the printer. So this is version 1.1 of the Constitution. And of course, we've updated it since, but these amendments end up being very important as we talk about specific rights. And some people get very strongly militant about their favorite amendment, whether it's the 5th or the 2nd or the 1st, or in this particular case, the 4th. But as a private sector CISO, I might care about this because, as I understand it with the FISA courts, they would issue a warrant saying, you have to give us the information on this particular customer, etc. However, you're not allowed to tell anybody, particularly that person that we've asked about, but anybody in general, you can't tell them that you have been served a FISA warrant. And so as a result, it meant that companies were sort of in that uncomfortable position that they had a legal obligation with significant penalties if they talked about it. Well, rescue hacker. What happens if someone said, hey, how about we put a FISA canary in our quarterly report? And so we saw some companies that were telecommunications firms that would have in their quarterly report, their 10Q, this organization has not received a FISA warrant this quarter, because you're allowed to say that. That is not prohibited. In the next quarter, this organization has not received a FISA warrant this quarter. And the following quarter, nothing. A canary in the mine shaft is an ex-canary. And so as a result, they were able to alert customers, their world, etc., that they were served a FISA warrant, even though they didn't say it, by simply having the contrapositive, if I remember my mathematics correctly. So the point is that what do CISOs in general need to think about in being able to be prepared if they are potentially subject to things such as subpoenas, national security letters, FISA directives, things like that?
Well, first of all, you have to comply with the law.
Yes.
And at the risk of thinking like a devious attorney, suppose we have an individual who is one of our overseas offices, and suppose that individual is here visiting the headquarters in America. And suppose further he or she is under suspicion by one government agency or another. And suppose once the person is here, lo and behold, they're going to be indicted. What does that mean to the CISO? Well, it means to the CISO you have to comply with everything. It also means that potentially that employee might sue you for smearing their reputation because this indictment is now public and you have to comply, and they just feel bad about it. Now, can they sue you? Answer, yes. Will you need an attorney? Answer, yes. Will the company cover your butt? Not necessarily. And so it's always good to have one eye out as to what can go wrong.
That's a good point. Now, I know we'd had Tim Brown on the show last year, and for those who remember Solar Wind.
Oh, yeah.
And what he went through, and that company stood behind him. He racked up over $1 million in legal fees just in his own personal defense. And I had him on the show, and he has moved on, but I have to say that he was quite fortunate to have a collegial working relationship with the
Let
company.
me say, Mark,
him.
he was damn lucky. I don't know about fortunate.
Yeah. All right, we'll be technical about it. Yes, I think that's the correct term.
You cannot assume that your employer is going to cover you 100%. That would be
that might be
my advice. Oh, yeah. I'm not giving legal advice here. We're just having an educational chat. I'm also not Mark's attorney, and I'm certainly not your attorney.
Mm-hmm. And so what we find then is that in circumstances, if you're looking for a new job as a CISO, maybe put that in your contract language to make sure that you got some coverage. But again, don't just talk to HR, talk to legal. Well, let's go ahead and move on to the second segment, which is a recent Supreme Court case. It was Chatry versus the United States of America.
I really like
And
that one.
basically, yeah, if I read through almost all of it, including the dissenting opinions, when I take the time to read Supreme Court rulings, I love reading dissenting opinions because it looks like the filters come off for the most part on the associate justice who's writing them. But you also gain other insights in terms of how to take a look at this case. But for those who aren't familiar with, I would assume most people aren't, there was a bank robbery, and some people that were in the vicinity of the bank robbery said they saw the person look like the suspect talking on his cell phone just immediately prior to that particular incident. And so what had happened was the police created sort of a 3-stage warrant, and they got it signed off, which basically said they went to Google and they said, give us everybody who was in this area, and this particular geofence wasn't very far, just a couple hundred meters from this very limited time frame. But don't tell us names, don't tell us addresses, don't tell us phone numbers. We just want to know in general. And then based upon that, they kind of windowed down the numbers saying, this person's from out of town, it's whatever. And they said a second pass. Okay, well, let's go to people who had been, moving in and out in this particular area in that time. Because if somebody just happened to be walking past the bank, they would have been detected in level 1, but not level 2. And finally, number 3, they narrowed it down to just 3 individuals, of which one of them happened to be the person of interest. And when they arrested that person, they happened to have in his possession some of the cash that was allegedly stolen, along with the signature of the bank teller who was allegedly held up. So we're going to say all those allegedly things because he was convicted. And what came out of that then is her attorney said, well, we're going to file a appeal based upon how some of this evidence was attained. And it worked its way all the way up to the Supreme Court of the United States. And it came down to the concept of geofencing, which a lot of us are familiar with, which says we're only going to look at a particular location, whether it's lat and long, a radius from a cell tower, however it happens to be defined. So first of all, what is a geofence warrant? And then what happened specifically in this case beyond what I've already mentioned?
Well, as I understand it, the court basically said you can get warrants, but a detailed specific warrant like that is unreasonable in the spirit of the Fourth Amendment. A generic warrant, reasonable. And as I did in the last case, you look at how the conviction was obtained, the flow of the evidence. And so we had evidence that led to the winnowing down of the 3 people. The detailed nature of the intercept, if you will, was unreasonable according to the court. And that's what they decided, as I understand it.
Right. And what I had understood is that the 5-justice majority concluded that individuals have a reasonable expectation of privacy and detailed location information because cell phones are essentially with them all the time. It is part of your life. It's almost an extension of who you are. And even Justice Gorsuch agreed with the judgment. He had different reasoning, so it gave a 6-3 result. And it basically said that that was too intrusive. And the reason being also, if you read through some of these opinions, is that because that information is recorded at very precise intervals, we're talking about once a minute or two instead of once a day or whatever, and that could go back days or weeks or months, you could theoretically reconstruct somebody's entire movement and activity from this information. And if you plug in your Google phone and turn it on, it's going to say turn on location services. And if you don't, it keeps telling you, well, things aren't going to work right if you don't turn on location services. And the point was also made in the case that it kept nudging to say you got to turn this stuff on. And so as a result, what happened is that every device we carry with us serves as a homing beacon to document exactly where we went and when we went, and to a certain extent, even what floor we're on if you're in a high rise, because that information can be obtained based upon the information that's generated on your phone. Now, the court said, yeah, you can't do that. That's too wide of a sweep. You couldn't start with a bigger number and then work your way down. And the other thing they also said is that although the warrant, if you go back to that Fourth Amendment and that useful legal stuff, it should be oath or affirmation, particularly describing the place to be searched and the person or things to be seized. In this particular case, they said, well, somewhere around here there was somebody, but we don't know who. And oh, by the way, we didn't just ask for one round of warrant. They said, give us something, and then we, the police, will decide to progress to layer 2, and then we will decide to go to layer 3. You didn't go back to the warrant issuing authority to say, hey, I need a second and I need a third warrant. So a lot of legal issues involved. But what was maybe important that came out of this was, what did the court not decide?
Well, I think it could be fair to say, Mark, that the court decided that in this particular geofence warrant, they weren't sure it satisfied the Fourth Amendment or not. And ordinary use of a smartphone doesn't necessarily, according to this decision, is not consent. Ordinary use of a smartphone is not consent because the citizen has some expectation of privacy. I think as an attorney, and I have another hobby, I'm a part-time judge in a small claims court, I would have to say that it really depends on the facts of the case and how law enforcement got to position the defendant in a particular place and how law enforcement accumulated enough probable cause, if you will, to get a legitimate warrant. I think it's pretty clear to me that this case doesn't mean that warrants or geofence warrants are prohibited, but that there needs to be some safeguards, and that the finer the detail, the more likely the court is going to reject, because the implication is that merely turning on my cell phone is not permission for the government to track my every move. I think that's probably the way it'll go down.
I think it's interesting. And it also kind of refers back, for those who are legal trivia experts, to Carpenter versus United States from 2018, which basically said that law enforcement needs a warrant to access historical cell site location information, known as CSLI, which is much less precise and also less frequent than you would get from your cell phone that you carry around and things such as that. And so what's interesting is that the court really said, because you're using a modern application, like something in your cell phone, that doesn't necessarily mean that you're surrendering your constitutional protection.
That is correct.
It's not in the terms of service to say, if I click here and turn on my location history, that I am suspending my protections under the Constitution. And so if I understand what you're saying here, Chapter doesn't mean that geofence warrants are not prohibited. It just really means that they're going to have to be much more carefully defined.
Yeah, and at the risk of jumping ahead, I think it may be useful to look at the GDPR and the way that it limits the storage of information. And so CISOs and data privacy officers need to be very up on what is the data retention policy of the company, and to ensure that the data is not retained for any longer than is absolutely necessary, particularly if all employees are using company-owned devices, because it's company-owned device. You, as the counsel for the company, the security counsel, are responsible. And so it's your job to make sure that compliance is routine.
Now, what's interesting is that, sort of as a response to this, because, by the way, Google had received dozens and hundreds and thousands of subpoenas asking for location history based on the information in the cloud. And part of the other reasoning in the case was that just because you store some of your information in the cloud doesn't mean that the cloud is separable from you and your control over it. But Google no longer, as of 2025, stores your location history in their cloud. It's stored only in your device, because there's already some pretty good case law that says what you can and cannot pull out of somebody's cell phone. And so as a result, Google said, look, kind of like Apple, we're just not going to become the tattletale for the world. If you want to go ahead and find information about somebody, you're going to have to do some better gumshoe work than just asking us to go ahead and do stuff. But what do you think from CISOs and privacy offers and things? What can we learn from this particular case?
Well, I think this again goes back to my good friends in the GDPR. And that is, you
Mhm.
have to know what data you have. You have to know where it is. And you have to only be using that data for the purpose that the data owner gave you consent for. And you have to
Mhm.
be deleting that data after it has served that purpose routinely.
And that was interesting because when GDPR first came online, and part of that included a right to be forgotten. It's sort of misunderstood by a lot of Americans. They said, oh, right to be forgotten means you did lots of dumb stuff. You posted, here I am throwing up at a party on Facebook on a
No, no,
Saturday,
no,
and
no.
Monday morning I'm interviewing for a job, so I want that
Yeah.
forgotten.
The internet is like toothpaste, Mark. Once it's out of the tube, it's out of the tube. It's not going back.
Exactly. Plus, it's not how the lawyers or the legislatures, they write laws, but they're not data scientists and not architects. They have no idea how these things are put together. And they're basically saying, for example, well, you need to go ahead and take this sugar water and separate it back into water and sugar. And it just doesn't work that way unless you put a crystal in there. But nonetheless, let's go ahead and move on to number 3, which was the CMMC or Cybersecurity Maturity Model Certification. I want to bring you in on this call because I'm a little bit more familiar with this. I've been in the CMMC ecosystem for almost 4 years. And what that was is that it was the Department of Defense at the time said, what we want to do is protect against the hemorrhaging of information that's going out of the national asset area that's not classified, but it's still important. We've got controls for confidential, for secret, for top secret. We have code words and letters and fun things that go beyond that point. And all that is well established. And the problem is that you can infer an awful lot about what's going on from what somebody else is doing by looking at those things that are not completely classified.
Yeah.
And so the U.S. has renamed that controlled unclassified information, or CUI.
Well, I think it's also fair to say that the U.S. intelligence community, like others around the world, has turned to open source intelligence, OSINT, acronym,
Mm-hmm.
as a principal source of intelligence, and that they're using AI at various flavors to sort through this stuff. And so knowing how many rolls of toilet paper are being shipped to point A might tell you how many butts are over there. And so extrapolation of class CUI used to be sensitive,
Controlled,
used to be
unclassified.
sensitive but unclassified.
And it used to be FOUO for
And that's
official use
right.
only.
You're old enough to remember FOUO. And so the fact of the matter is that seamless, worthless information has become worth something because of the ability to vacuum it up and to use AI to sort it out. I think that's pretty fair.
Now, what had happened is the CMMC came up with 3 different levels. They've gone through a couple generations. The first phase, you're going to have maybe 1, 2, 3, 4, and 5. Second phase, they collapsed it down to 1, 2, and 3. And they said, okay, level 1, if you're just going to go ahead and do federal contract information, you make ballpoint pens and you get orders from various government agencies. Well, it's not really critical if somebody understands how many ballpoint pens are ordered, but it is federal contract information. So you have some fairly limited security controls that you should have in place, almost but not quite along the lines of something as simple as a PCI DSS, Payment Card Industry Data Security Standard. When you get to level 2, though, the governing document is National Institute of Standards and Technology Special Publication 800-171, which has 110 different controls. And all those are designed to help organizations put in the control base so that if foreign entities or adversaries are targeting American information that's held by corporations, they're going to encounter a lot more difficulty in doing so because we're using good security hygiene. Well, the first round was this level 1, 2, or 3, when you're doing really sensitive but still in class, all required an outside certification. The small companies that were making things such as ballpoint pens howled about that, saying, well, we can't afford to, and besides, you don't have enough people. So they said, okay, level 1 can be self-certified, but level 2 and level 3 require a full inspection or assessment. Now, what's happened is that there was a recent announcement that was made that it's suspending the transition to phase 2, which was going to be in November of this year, and no longer requiring the full certification level 2. They could be self-assessments. Well, self-assessment is a little bit like attesting to the fact that I did 1,000 push-ups every day.
Me
Well,
too,
unless
Mark.
you're asked to, when you're asked to prove it, it's a different thing. But if you just have to attest that, that's one thing. That has been the problem in the past. So there's an entire ecosystem out there. There's the Defense Industrial Base Cybersecurity Assessment Center, DIBCAC, deals with level 3. The CMMC Third-Party Assessor Organization, C3PO, deals with level 2. You got familiar with all that. I'm not going to go ahead and run down the acronym soup simply because unless you're dealing with the Department of War, NEE, Department of Defense, then you don't really care. Although it's quite possible that at some point in the future, that may occur with other federal agencies when they look over and they say, hey guys, that actually isn't such a bad idea. So does that mean that defense contractors should just say, whoa, I'm off the hook. I should no longer have to prepare for this level 2 certification?
Not my world, but I'll comment as a general contracts attorney. It strikes me that you need to do due diligence anyway. The mere fact that a formal requirement has been suspended does not excuse you from doing the right thing and improving the security that is reasonable under the circumstances. So I would say that just because it's gone, it doesn't mean you shouldn't do that. Now, depending on how important the government world is, if I was general counsel, if government contracts are really important to me and I'm concerned about liability, I might retain an impartial third party to do a certification. While it might not be the official government acronymed group, it still is good evidence of due diligence and proper intent on my part.
Well, I think that's quite true. And also the thing is that things that go away by themselves can come back by themselves. And so that's one of the things to keep in line.
Yeah, I think that's a good point, Marcus. Even if you don't hire a third party, you should, as a prudent CISO, document what you're doing as evidence of due diligence and prepare for a third-party government certification, even if it's not prescribed in the law, because it's evidence that you are doing the right thing.
And one thing to be cautious of, you can increase your legal exposure if you do a self-assessment and lie about it. Or you falsely represent compliance when you're trying to get a contract, because there's something called the False Claims Act, and it can be used against government contractors who knowingly violate the law, including cybersecurity requirements. Have you heard anything about the False Claims Act?
No, I'm not a False Claims Act guy, but I'm a fraud guy. So fraud, material misstatement of a material fact made for the reliance by that other party. So if you say, for example, we are using umpty-ump encryption with a umpty-ump level, and you're not, that's a fraud. It's a misstatement of a material fact that you're intending this other party, the inspector, the government, whoever, to rely on, and you would be on the hook, clearly on the hook.
Yeah. Okay, and so kind of a question to put all this together, if we kind of skip through, because we're almost at the end of the show here. Are there any common lessons that connect these developments with regard to what we should think about in respect to the law?
Well, I think respect to the law is that surveillance has not ended. Geofence warrants have not disappeared, nor will they. And that the CMMC certainly has not been repealed, even though inspection provisions have been suspended. And that the prudent CISO is continuing the march like they know an inspection is coming down the road. And if, in my own personal opinion, if they find things a little confusing, they can always look to the GDPR for what's going on. They have to, but CISOs have to understand not just what's changed, but what didn't change. And so FISA is still in business. And It underscores the need to have a good relationship between security, which may be physical security or a chief security officer, legal, for our brothers and sisters, compliance, privacy, purchasing, among others, and of course, HR, because cybersecurity for the CISO is a team sport after all.
I concur. And so thank you very much, Larry, for your thoughts and ideas on this. For everybody out there, if you faced any of these issues directly, please let us know. Go to LinkedIn and look us up at CISO Tradecraft and give us your comments. We'd love to continue this as an ongoing dialogue. If you're following us on YouTube or any of a number of podcast channels, thank you. If not, please go ahead and subscribe so you can go ahead and get our information. Also, if you follow us on LinkedIn, you'll get more than just a podcast. You'll be able to get a daily, or not a daily, but fairly steady dose of what we consider to be high signal, low noise information that's very relevant toward your career. And so thank you again for being part of CISO Tradecraft. Larry, again, thank you very much for your time and your friendship over the years. And for everybody else out there, till next time, stay safe out there.